Act 250, Bill 926. Before we start with much counsel, I'd like to go around the room and have folks introduce themselves while we face this committee.
My name's Helen Van Beck. I'm an intern with the Transportation Agency.
Andrew Brewer with Down by
Thomas Weiss, resident of Montpelier.
Hi, Terry Persons, Vermont Bar Association.
Mona Mahar, Vermont Ski Areas Association. Jane Clifford, Vermont Farm Bureau.
Tess Kennedy, William Schuldeis and Associates.
John Brabant. I'm with Vermonters for a Clean Environment.
Nancy Lynch, Vermont Association of Realtors.
Ed Stanek, retired guy from Barron.
Renee Carpenter from East Montpelier.
Matt Chapman, Agency of Natural Resources.
Hannah Johnson, Internet MMR.
Jamie Fidel, Vermont Natural Resources Council.
Julie McDonald, The Crossing Group.
Mike Bailey.
Okay, great. Well, welcome everybody.
And I'm Ellen Czajkowski with the Office of Legislative Counsel. I don't think I have been before this committee since I was an intern with Legislative Counsel 5 years ago. I interned with Michelle, so you probably haven't seen me before. But I am the Leg Counsel who works on natural resources, and most of my time is spent on Act 250. So I'm here on H926. H926 is an act relating to changes to Act 250, and there are a lot of changes in the bill. The bill came out of a pretty long process that originated with the Commission on Act 250 the next 50 years. And that commission was directed to look at the history of Act 250 and make recommendations on modernizing the act. So then House Natural Resources spent the last year working on those recommendations, and so H926 has a lot of different changes in it. So I have provided you with a chart that has the broad categories and where they are in the bill. So
That's posted? Or will be posted?
It is posted.
Okay.
and so the part that I think is most relevant to this committee is the changes that are happening with the permit appeal structure. So currently, the district commissions issue Act 250 permits. Those permits can be appealed de novo to the Environmental Division of the Superior Court.
What does de novo mean?
A fresh, it takes a fresh look at all of the evidence that's submitted. So they take what the district commissions have gathered, but the parties are allowed to also submit evidence, and they hear the case anew. So appeals from those decisions then go to the Supreme Court if anyone wants to appeal a decision by the Environmental Court. But H926 is changing the permitting structure. So you may have heard that there will be a state board. The Natural Resources Board will be 3 permanent members, and they will work with district commissions on major permit applications. District commissions will still issue minor permits, but appeals of both the minors and the majors will go directly to the Supreme Court. So the Environmental Court will retain its jurisdiction over A&R permit appeals, local zoning permit appeals, and enforcement cases, but they will no longer hear Act 250 permit appeals. And so that language starts on page 72 of the bill, and it's in sections 10 and 11 of the bill. And basically I went through the Environmental Division's jurisdiction and struck all the references to Act 250.
So can you just say what page that's on again?
It starts on page 72.
Thank you very much.
Do you want me to go through it? All it does is strike all the references to Act 250.
It would be good to focus us on a specific section that we are
Sure.
looking at and how it's done.
Do you use the projector or? Okay.
I'm gonna do a little bit of that. The committee, we don't have possession of this bill.
Yes.
What's that?
30.
There are,
30 is.
Ways and Means is looking at it now. I don't know if Government Operations is looking at it now, but I think we will. And appropriations to be looking at it as well.
I know our focus is going to be very, very narrow as far as the judiciary system goes, but I'm just wondering where the bill came from originally.
Sure, it was a committee bill from the House Natural Resources Fish and Wildlife Committee. And it is currently in Ways and Means.
Their possession or?
Yes.
Okay.
Yep. It has fees, so it went there last week when it was introduced. All right, so 10 VSA, Chapter 220. The committee had me strike the reference to consolidated, but this is the environmental appeals chapter. So, in the purpose section, it is the purpose of this chapter 2. I strike the reference to the district environmental coordinators and district commissions, which are part of the Act 250 permitting process. And then on page 73, I strike the reference to the language that currently is in statute that encourages people to get involved with the Act 250 permitting process at the initial stages. Again, that won't be part of the court's jurisdiction any longer. Technical correction on line 8 to change assure to ensure. And then the next change is on page 74. So it strikes the reference to the environmental court having jurisdiction over appeals from district commissions, which they issue the permits currently, and then appeals of jurisdictional opinions by district coordinators, and then appeals of finding and fact and conclusions of law, which currently are done by the Natural Resources Board. So those are all the Act 250 permits, appeals under current law. And then in section 8504, again, strike the reference to Act 250 appeals and district commissions and district coordinators on lines 13 through 15. Down at the bottom of page 74, we start again striking an appeal from the district commission, so we strike that language. And then again on page 76, the requirement to participate before the district commission or the secretary, strike the district commission because that's part of the Act 250 process. And then the language about participation before the district commission. So that's all struck. Onto page 77. You renumber those sections. And then on page 78, starting on line 11, strikes the appeals over Act 250 jurisdictional determinations by the district coordinators. So that's struck. And then on page 80, again striking reference to use of permits in other permits as part of the Act 250 permit process.
Where's that on page 80? Okay. At the bottom.
Line 7.
Okay.
Yep. And then line 17, striking again the reference to district commissions. Page 81, line 4, striking reference to the district commissions. Line 8, striking reference to the chair of the Natural Resources Board, may represent the board in appeals. At the bottom of page 81, intervention, strikes reference to the Natural Resources Board as a person who may intervene in a pending appeal. At the bottom of page 82, striking the reference to, again, appeal of a decision of the District Commission. And then finally on page 83, in section 11, for VSA section 34, jurisdiction of the Environmental Division, we strike reference to the original jurisdiction to revoke permits. So that, under this bill, the new professional Natural Resources Board shall have the jurisdiction to revoke permits. And that is all of the environmental court references.
Where in the bill would we find the provisions about how appeals, activity appeals would be adjudicated under the new
Sure, so
body?
it's one of the sections on this chart too, so it is in here. There is a few different places, but under both the powers of the new board and the appeals section, which is section 6089 of Title 10.
Section 6000.
Yeah. Did you want to look at that language?
I think I can find it. Could you just say that one more time so that's the
6089 is the appeals section.
What's the bill section number?
Oh, it's so most of the bill is in section 3 because it amends all of chapter 151. So it's on page. Let's see. Yeah, it might be 61. Yeah, it starts on page 60.
Okay.
Yep.
I guess just a blanket question, like how closely does the new proposed appeals process mirror or differ from, a judicial appeal through the current environmental court model? So that's probably a good question.
Well, so it will be very different. We're skipping the environmental court as part of the new appeal process, and so the Natural Resources Board will issue appeals, and those appeals will be able to be those permits will be able to be appealed to the Supreme Court. So it will be different.
So any appeal just goes, the Natural Resources Board issues the permits,
Yep.
but doesn't hear the appeals just go straight up to Supreme?
Correct.
Okay.
Right, and that's what we don't have, and I think that's important for us.
It's page 62, subsection
Thank you,
B.
Selena,
Yes.
for.
Yeah, can you repeat that,
Yeah,
Selena?
So the new Natural Resources Board makes the Act 250 permits, and then the appeals no longer will go through the environmental court, but any appeal would go straight to the Supreme Court of an Act 250 permit, right?
Yep. Yep.
But the environmental division will retain A&R local.
Yes. Yes.
Any other questions about how this works in terms of the appeals and what is changing in terms of what does and doesn't go to the environmental division?
So I know that, I'm not sure about recently, but I know in general there was a long delay for cases to go, that were appealed, to get into environmental court. Is one of the purposes of this bill to sort of, well, I shouldn't say that, but is one of the outcomes that fewer cases will end up going to the environmental court? Or not necessarily?
Well, so no Act 250 appeals will go to the environmental court.
So that's already eliminating a bunch that were now.
Correct.
Okay.
Yeah. The committee was interested in streamlining the process, and so removing one layer of appeal was what they decided on.
And you don't know the volume of how many?
I do not, but I suspect someone here does.
Good.
This person will be testifying.
Can I just ask it? So, and it looks like, so the final, what I'm reading and understanding about this, the relationship to the Supreme Court, so the final, all appeals of final orders will automatically go to the Supreme Court, and then the board can kind of refer a question earlier in the process to the Supreme Court for just an opinion or weighing in.
Yeah, like an interlocutory kind of appeal.
Yeah, so your question makes it sound like an advisory approach.
Well, right.
Yeah. It's not.
Yeah.
There's,
So this is language this is very similar to how the PUC operates currently. So that language came out of their sort of structure.
PUC?
The Public Utility Commission?
Okay.
Sorry.
That's all right.
My question's for a witness.
Selena. You good? Or-
Yeah, I'm just trying to make sure I understood it.
I guess, what does this do to the environmental court? It takes a lot of litigation out of their hands and puts it in the Supreme Court? Yes, no?
I'm not sure if I would characterize it as a lot. It does take away what a part of their jurisdiction currently.
Right,
And that's what we'll be talking to Judge Grearson about.
yeah, okay.
Anything else? Any other questions on drafting resolutions? Great. Your Honor.
Thank you.
Good afternoon.
Good afternoon.
Brian Grearson, Chief Superior Judge, to testify on H926. And I think just to pick up on some comments made by Representative Rachelson, let me just give you an overview, if I can, of the environmental division as it exists now. The environmental division has 2 Superior Court judges assigned to it. Although they were appointed to sit in the environmental division, they are Superior Court judges like any other Superior Court judge. The process for appointment is the same. On one level, they were appointed as environmental judges, but in reality, through my office, I can assign them to other assignments within the Superior Court. And by way of example, one of the judges has sat hearings in one county, assisted there. The other judge has sat both in the criminal docket and in the civil docket, landlord-tenant matters. So they have the skill set, they have the ability, and I have the ability to assign them to areas apart from the environmental division. But their focus is certainly in the environmental court, which for those of you who are not familiar with the process, it is essentially a statewide court, meaning that although the court, environmental court, if you will, is housed in the Costello Courthouse in Burlington, when they hear cases, they go to the county where the appeal comes from. In the course of their work, they are involved with Act 250 appeals from the district court, and as the first witness indicated, those appeals come to the environmental division on what is referred to as the de novo basis, meaning that the process, the hearings start all over again. There are, I guess, two schools of thought on that it's duplicating the work, both before the District Commission and the Environmental Division. There are some folks that view the ability to have a hearing, if you will, in a less formal proceeding before the District Commission, that they sometimes identify issues or minimize issues so that by the time they come to the Superior Court, Environmental Court, they may have refined the issues that need to be addressed by the court. When you hear proceedings in the Environmental Court, there is a more formalized structure. There are rules of procedure that the court follows unique to that court. So it is a more formalized process than what occurs at the District Commission currently. I guess I would disagree with the comment that they take a long time.
That may be
and that's all right, and I'll explain why. This division, like all our divisions, we set what we refer to as disposition guidelines. In other words, we look at the type of case coming into the court, whether it's family division, criminal division, environmental division, and we try to break down the cases in terms of their complexity, and we set guidelines for cases to move through the process. And we had done that with the environmental court. We sometimes refer to, as a measure of how a court is doing, a term called clearance rate. And what that means is we look at the number of new cases filed in any given year, and then we look at the number of cases that are disposed of in any given year. If we dispose of 100% of filings, not necessarily all the ones that came in, but if we dispose of many cases in a given year as have been filed, we refer to that as 100% clearance rate. What that means is that we're not building up any backlog in cases. We're moving the cases through in a timely fashion. So anytime a court can achieve a so-called clearance rate in excess of 100%, it means they were reducing any backlog of cases. The environmental court, I would dare say, is probably one, if not the best division in terms of that benchmark for success. The numbers, and these are available on our website, would show that in 2015 the clearance rate was 118%, 117%, 2016 103%, 102%, and the most recent number is 113%. What that indicates to at least the folks in the judiciary is that this court appears to be running not only efficiently, but not allowing a backlog of cases to accumulate, which can lead to delays. The other measure that we look at is how many of these cases are disposed of in the time frame that we have established, that a goal, if you will. And obviously not all cases meet this goal, but the numbers would show, I don't think I have that number right in front of me, but my recollection is from my testifying before House Natural Resources that over 80% of the cases are resolved in less than a year from 500, which I think, again, is a significant number. Now, obviously, what that does not account for is the time since the original permit request has been filed in the district commission. We don't have that information, or at least I don't have it readily at hand. But when these cases come into the court, what I'd like the committee to take away from this is that we've set guidelines. For the most part, we meet those guidelines, and the backlog hasn't developed. The types of cases that we process include the Act 250 that has been referred to in appeals. In addition to that, we also have enforcement provisions from the Agency of Natural Resources Board. We have civil violations, we have municipal appeals, permit appeals, municipal enforcement, and other, they're called on the record appeals, but they're from municipalities. There's a small number of municipalities that have elected to take that process, so that's a very small number. Overall, the numbers would show, with respect to the Act 250 cases that at least this bill talks about being removed, for instance, is a small number. The committee should be aware of that, and the number, I want to say in 2000, fiscal 2018, there were 13 district commission Act 250 de novo appeals. And fiscal 2019, there were 8 district commission de novo appeals. So the numbers of the type of case that would be moving out or would no longer come to the environmental division is a relatively small number. Having said that, I will tell you that they are, generally speaking, more complex cases, but it is a small number. But because of all of the other matters that this court and the judges address, or have to address, and will continue to address, even if this bill goes through, there will still be phrase it the right way, there'll still be plenty of work for the judges to do. So this is not a situation where, as you're looking at this bill and looking not only at the policy behind it, which we're not obviously going to testify about or offer a position on, and we're not going to get involved in the whatever the costs may be attendant to this change, other than to say that the resources of the environmental court, even if this bill goes through by removing the Act 250 appeals, would essentially remain intact. And the reason I say that is that these judges are independently appointed judges, as all the Superior Court judges are. The staff that's involved with the operation of the environmental court also has other duties throughout the judicial system. In fact, some of the staff members have been working with the court system longer than many of the judges, including myself. And they have multiple duties in multiple dockets. So we would not see that the removal of these cases from the environmental division would leave any reallocation of resources from the judiciary to help finance whatever proposal is adopted. I think that's an overview of what we see as the implications of this bill. Those are the numbers that we deal with. And I'm glad to answer any questions.
That's helpful, and that is the focus of our jurisdiction.
So I just want to say my information is super old, and I was just looking.
It's okay.
It's before there was a second judge, so I'm glad that there are 2 judges, because back in the early 2000s, it was a long time. So good job in getting it.
We had issues
Yeah.
that were addressed, and and there is work, obviously work for both parties. And there will continue to be judges. Obviously, this will have an impact on the Supreme Court. We haven't been able to provide numbers for the committee, but presumably there could be a fiscal impact in respect to the Supreme Court's work. The difference will be, as I've said, that the appeals now come to the Environmental Division for rehearing, essentially, and evidence is presented and will follow. The difference will be that now the Natural Resources Board, the primary entity, will be hearing these appeals, will have to create that record, and it will be the record that they create that will now go to appeal on the Supreme Court on what is referred to as on-record appeal, which is just the opposite of de novo, meaning the Supreme Court is going to look at the record that was fashioned below and decide whether that record supports the decision. And what I mean by that is that in every hearing process, evidence is presented by various parties, and from that evidence, the court, in any proceeding, makes a determination of findings of fact based on that evidence. And from the facts that they find, they make legal conclusions. And those conclusions lead ultimately to the order. So when the Supreme Court is reviewing that on the record decision, they are looking not only at the order and the conclusions, but they are looking at the findings of fact and whether or not the facts as found by the body support the conclusions. And that would be, among others, a critical function of the Supreme Court on an on-record appeal. That's the importance. Let's put it this way, the appeal is only as good as the record that supports it, I guess is the best way to explain it. And that will be a big difference from what is in existence under the current system. And this system has been in effect, I want to say 2004, 2005 perhaps. And one of the elements that exists under the current system that I believe, as I read this bill, and I'll go through it and talk with the environmental judges, again, one of them made the comment that sometimes when an Act 250 appeal comes in, there are other permits involved, municipal permits, and the court has the ability to consolidate some of those proceedings so that at the same time they're hearing an Act 250 appeal de novo, they will be hearing the appeal of the municipal permit, and they will essentially consolidate those for hearing. Under the, as I understand this structure as in the H926, that will not be possible. In other words, those appeals, municipal appeals, will still go to the environmental board. So you'll have the agency making a decision here and the municipal, the environmental division still making a decision. And at least one of the judges pointed that out as something they.
Not right now, I guess.
It's pretty complex.
Yes?
I'd be glad to come back at the committee's invitation if there are questions that develop testimony of other witnesses. Hopefully that gave you what you were looking for
Yes.
today.
Absolutely. We do have another question. We're gonna switch gears. So we're done with this. But while I have you, can we ask you something regarding firearms and record retention?
Yes, you may.
When firearms are relinquished, and the state has them in their possession, and they have, of course, who the owner is, make, models, serial numbers, and and all the pertinent information, the number they may have of firearms from a certain person. So when the you go through the process and, excuse me, the firearms are given back, how long is that information retained and how is it deleted?
That may be a more appropriate question for who's ever holding that information. In other words, we might not have, the court wouldn't necessarily have that information. If you remember the way the bill was coming in, they were going to identify on the return if they collected firearms, and there might be some information there, but that might be limited to 3 firearms. And at a final hearing, we may never know, we may not know in advance of issuing the court order exactly what firearms are relinquished.
Wasn't the language that the
Return
court
return.
system had that information?
Return of service.
It will be returned to the court or something.
Is there, in terms of current practice, is
Yeah,
there?
yeah, I was just gonna ask.
Yeah, when guns are relinquished or seized or anything
Well,
like that, is there?
If someone comes in and goes through a third party approval, then we normally would have a list, a specific list of what firearms have been turned over.
And what happens to that list when the order, let's say when the order expires?
That is part of a court order, so the order remains a court document. If it's, let me put it, I'll make it simple. If we are provided with a record of what has been relinquished, and what I was trying to say was our records may not be complete, but if we receive a list of firearms that have been relinquished, that is, and if it's part of the court record, which either it would be by return of service, or if there was an affidavit filed saying, I have taken possession of the following firearms for defendant X, and I agree to not allow that individual to have access. In other words, if we have a complete listing, that'll become part of the court file, and they will remain in the court file as part of the court record.
The list of firearms?
Yes.
Even if it's determined that there was nothing done that was unlawful, or the court still keeps a list of somebody's possessions?
If it's part of a court order, part of the pleadings in a file, it remains part of the court's file. I mean, there's nothing that I can recall in the law that requires us to remove that information.
So, you kind of, I think you alluded to that somebody else might have this information too. Would that be like a police?
Well, I'm thinking law enforcement.
Law
I mean, there are in my experience, there are very few third-party or relinquishment storage with firearm dealers. My experience is they are predominantly law enforcement. So they have whatever list they would have, or whatever list a firearms dealer has. We have no control over that record. So, in law enforcement, obviously they are going to maintain an accurate list of what they take into possession, but that's a separate list than what's filed with the court and what they do with it after the fact.
So, would an individual be able to seek to have that list that the court has sealed? I mean, there could be a motion to seal such a record. I mean, if somebody's subject to an order is concerned about having the information about his or her firearms in a public record, could they, in fact, move to have it sealed?
The short answer would be there's nothing that prevents somebody from filing a motion to seal. It's up to the individual judge whether they think there's a basis for sealing records. As a general comment with respect to any type of record, whether it's firearms or medical records or financial records, the courts are reluctant to seal records that have already been made public.
But those other records wouldn't necessarily be with other people, like a police force or a dealer, or they wouldn't be spread all over the place, they would just be with you.
You're talking about the medical or
Yeah,
financial
yeah,
records?
yeah.
In an individual proceeding, but if they become part of a court file and they are not sealed in advance, they're already out in the public. And so, yes, you can file a motion after the fact to seal them, but we don't have any control over what has already gone out
Right,
to the public. And that's why I'm saying that someone could petition to have those records sealed, but having the ability to file the motion and having it granted are two different questions.
So I actually thought the question that we had was, let's say there's a petition that goes to court, but it's denied. Or is that information being kept? Because this morning we were having a discussion about people who did do nothing wrong, and it turned out we didn't need to remove their weapons, but somehow the court would still have the list.
So you mean like in the affidavit or something, if it was?
Right, if you're denying the ERPO,
Or the emergency order? Or
right, yeah.
The permanent.
Are those part of a permanent record, the ones that are denied?
Not if they are denied, if someone applies for an emergency order and it's denied, number one, no firearms are taken, and that does not become public
Right.
if it's not.
But somebody might have said, I know Fred has this gun and this is the serious, like,
So the complaint, what happens to
right,
the complaint?
yeah.
The affidavit and complaint.
But if
for an
it's not,
argument.
if it's denied,
Right.
Where
in
does
other
it-
words, if the court doesn't grant the request, then it doesn't become a public record.
And it just goes away, gets shredded or something.
No, it doesn't become a public record.
Okay.
And I will confirm that, I'll verify that. There are different steps along the way when it becomes public or not public. But if the request is denied, it is not public. But it doesn't mean it would shred it.
But if a temporary order is issued,
Then
you would have,
we'd have a hearing. It's
but
set
you
for
would,
hearing.
but with the temporary order, aren't the firearms relinquished?
It all depends.
They can be, even now
Right,
they
they
can
can
be.
be, right,
Yes.
but then,
Yes.
so then they would be relinquished, there would be a list that the court would have and say when the hearing came for the permanent, it was denied, you would still have that list of somebody's personal property.
You would.
Yeah.
I mean, much like in many other types of proceedings,
Right.
if you have a domestic matter, a divorce proceeding, there are pages after pages of what people own by way of possessions because they're disputing. So there's all kinds of information in court files that is very personal. And
I look at this as being a little different than that. I see the similarities, but.
I'm just saying what becomes public. I mean, there's a lot that
Right.
can become public. And all I'm really saying is if you're looking at it after the fact, if it's already been made public, then you could file a motion to seal, but there's nothing at this point automatic about it.
So what does that mean when it becomes public? That anybody can look up and see this information?
If it's public, yes. Court records generally are public records.
Essentially,
Juvenile
firearms
proceedings
is
are
the target,
confidential.
you know, Potentially targeted possession. I don't know, at some point, I would certainly like to look at it a little closer. See if somehow the system of all this information is being collected on firearms can't be streamlined somehow. Have them go into the FFLs having information, potentially police having information, potentially court system having, you know, the information in a real way right now. Especially in cases where permanent RFAs are issued, to me, that information should come out of the system and not even be available. That's just me.
All I can tell you is that when you issue an order, there's always it could be an issue of enforcement. And so that's why the orders remain, for the most part, public.
Right. No, I realize it
Because-
would all be after the fact that, you know, it went public, but,
You're trying to get the ketchup back in the bottle.
As a waitress.
can be done.
Right, it's called marrying the ketchup.
That's right.
No, I realize you can't put the ketchup back in the bottle, but maybe you can avoid a little spillage, I guess.
I'll let the committee,
But that's,
wrestle with
yeah,
that.
that's a road.
That's
We're not gonna settle that right now.
Yeah, supplemental, so what we're just,
So can you just walk us through how somebody can access somebody's court record?
Patricia's probably the best one for that. But literally, you can go to the courthouse, and if you're aware of a public, of the litigation, and assuming it is a public record, all the juvenile records
Right.
are confidential, so
Sure.
you can't access those.
Right.
But if I wanted to see a copy of, well, let's say that there was a, it's not uncommon for attorneys, for instance, when they've heard of a decision by a judge, that they may want to have a copy of that decision, so they can apply to the court for that. Many, obviously, individuals are self-represented. They have the same right of access as an attorney would. So if they wanted to see a decision in another case, because they said, gee, that sounds like what happened with me, I want to see why that judge ruled the way they did, they can go to the court and say, do you have, if they have the name of the case, the name of the individuals, they can request it. It is public proceedings.
And do people have to write their name down that they're asking to see the file?
I don't think it's not that formal. If you come to the
Okay.
clerk's office and you want a copy of a file and you have the names,
And you have to be in the right court, right? If it happened
helps.
in, okay. So if I went to Chittenden Court, but really somebody went to court in Franklin County.
I can say that, answer that at present, yes, they would have to go to the right court, but when we have a case management system, presumably you can access those remotely and from any court, is the idea.
Interesting. So that might be a cheaper way for people to do background checks than the, well, it's not full information, but anyway, it's interesting. Are you ever concerned about that? Like how,
Concerned about what?
who accesses it and why? It's probably a longer discussion. Okay.
I think that opens up a whole other
Yeah, it's
area. of,
fascinating.
um,
We'll have to chat.
I mean, they are public records.
Right.
And so whether
Right,
I have an opinion on that or not is really not all that important.
right. It's not like HIPAA.
Whatever my personal opinion is, they are public records for the most part, accessible to everyone.
I think this is a yes or no. So are they public record, is that a constitutional thing for court cases? It is, okay. It was a yes or no.
Great. Alright. So, we are set, today. Your adjourn. I'm glad to speak to you afterwards, but, the committee is adjourned.
well, I wanted to ask
I-
if I could
Can you please wait? Our committee is adjourned.